results of the state Supreme Court election on April 4th will likely have a major impact on Wisconsinites, and the national news media is calling Wisconsin's spring election the most important election in the United States in 2023. It will likely also be the most expensive state Supreme Court race ever held. The League's vision for the courts is a system where everyone in Wisconsin has equal access to fair, unbiased courts that are insulated from the corrosive impact of partisan politics and special interests. The League of Women Voters also believes that the methods of financing political campaigns should ensure the public's right to know, combat corruption and undue influence, enable candidates to compete more equitably for public office, and allow maximum citizen participation in the political process. This forum is the third in a series of presentations designed to inform our members and the public about the issues and choices to be made in the upcoming April election. The first forum, entitled The State Constitution, Are Changes Necessary? And the second forum, entitled The Wisconsin Supreme Court, Why Your Vote Matters, are both available recorded on our website. You can watch those recordings by visiting our website at lwvdanecounty.org. Tonight's forum is also being recorded and will be available on the League's website, and captioning is available. Our forum tonight is entitled, Should Judges Decide Cases Involving Their Major Campaign Contributors? The League of Women Voters of Dane County begins each program with a land acknowledgement that recognizes the Indigenous peoples who are the original stewards of the land we now inhabit. After that acknowledgement, I'll introduce our speakers, and in the last half hour, the speakers will address your questions. You can enter your questions at any time during the forum in the Q&A feature at the bottom of your screen. I will get those questions to the speakers on your behalf. Let's begin with the land acknowledgement. In owning our past and charting our future, we, the League of Women Voters of Dane County, recognize the Indigenous peoples who are the original stewards of the lands on which we now live, while we still struggle to learn more about the current and ongoing context of colonialism. In Dane County, we're all standing on the stolen ancestral lands of the Ho-Chunk people. We pay respect to their elders, past, present, and future. Please take a moment with me to consider the many legacies of violence, displacement, migration, and settlement that bring us together tonight. Thank you. Now, I would like to introduce you to our speakers tonight. We are honored to be joined tonight by Justice Louis Butler and Matt Rothschild. Justice Butler is the first African-American to serve on the Wisconsin Supreme Court from 2004 to 2008. He participated in decisions that have had significant legal impacts on the state of Wisconsin. He also spent a great portion of his career as a public servant, acting as a criminal defense attorney, an appellate lawyer, a law instructor, a state court judge, and a municipal judge. He argued before the United States Supreme Court and is a permanent member of the faculty of the National Judicial College in Reno, Nevada, where judges from across the nation and around the world take continuing judicial education classes. Matt Rothschild is the executive director of the Wisconsin Democracy Campaign. Since coming to the Wisconsin Democracy Campaign at the start of 2015, Matt has concentrated his work on raising public awareness of the need to ban gerrymandering, limit big and dark money in our politics, protect and expand the freedom to vote, and oppose the anti-democracy movements in our state and our nation. He is the author of 12 Ways to Save Democracy in Wisconsin, published by the University of Wisconsin Press in 2021. Prior to joining the Democracy Campaign, Matt worked at the Progressive magazine for 32 years. For most of those, he was editor and publisher of the Progressive. And we are going to get started with Matt Rothschild. So Matt, I will turn it over to you. Thank you so much.
Hey, thanks, Erin, for that sweet introduction. I want to thank the Dane County League for inviting me to be on this panel. You know, I love the League and all that the League does. It's also a real honor for me to be on this panel with Justice Louis Butler. who I've got great admiration for. And I really want to hear what Justice Butler has to say, so let me just try to set the table a little bit. 20 years ago, when Pat Roggensack was first running for the Wisconsin Supreme Court, and she, of course, is the justice who's retiring right now, the amount of outside money in that race was only $27,000. So far, in the current race to replace her, the amount of outside money is already at about $10 million. And that $10 million is double the previous record, which was set back in 2020. The outside money and the money to the candidates themselves from super rich individuals has just gone through the roof. I'm expecting the total amount spent in this race to reach between $30 and $40 million, which would be a threefold or a fourfold increase from the previous record. So how did we get here? I'm going to mention 3 U.S. Supreme Court cases and 1 Wisconsin Supreme Court case for context, and then I'll mention the horrendous rewrite of our campaign finance law in 2015, and then I'll briefly try to pinpoint when the big money first exploded here. But let me give you the overall picture. Here's a spoiler alert. What we're witnessing this year in Wisconsin is the sad and tardy eulogy for McCain-Feingold and for any meaningful attempt to limit how much the super rich and corporations can spend to influence our elections. As a result, they have a much larger say than the average citizen here in Wisconsin over who gets elected, what laws are passed, and what policies are pursued. And a lot of the big money is coming from outside of Wisconsin, which also raises the question of whether we actually have self-rule here in Wisconsin. But let's get on to the court cases. In 2007, in a case called Wisconsin Right to Life versus the FEC, the Federal Elections Commission, the U.S. Supreme Court ruled that so-called issue advocacy groups couldn't be limited in what they could spend at election time by the McCain-Feingold law. This allows dark money groups to spend unlimited amounts of money so long as they don't tell you exactly who to vote for or not vote for, and so long as they don't coordinate with candidates. They could just hide behind the bushes and throw mud at the candidates, and they don't have to disclose who's paying for the mud. Then infamously in the Citizens United case of 2010, the US Supreme Court ruled that corporations and other groups and individuals could spend unlimited amounts of money to explicitly tell you who to vote for and not vote for, so long as they don't coordinate with the candidates. And then in 2014, in the McCutcheon decision, the US Supreme Court ruled that aggregate limits on how much individuals could give to candidates and to PACs and to parties were also unconstitutional. The case involved an Alabama businessman named Sean McCutcheon, who'd already spent the then limit of $123,000 on candidates and committees, but wanted to spend more and insisted that his First Amendment rights were being trampled on, and the court agreed. And it should be noted that, these are First Amendment rights for only people who can spend more than $123,000. But anyway, that's what the court said. So the US Supreme Court, with these 3 decisions and some prior ones, has essentially said that there are no limits whatsoever on how much a super rich individual in the US can spend to influence the outcome of our elections. Here in Wisconsin in 2015, 2 additional things happened that made things even worse. First was the Wisconsin Supreme Court's decision in the John Doe 2 case, which, as you'll remember, was investigating Scott Walker for allegedly coordinating with outside groups while he was campaigning for office, which was illegal under a Wisconsin statute at that time. Walker's pals on the Wisconsin Supreme Court gave him a get-out-of-jail-free card by claiming that the statute was unconstitutional under the First Amendment of the U.S. Constitution, claiming that it forbids states from banning coordination between candidates and so-called issue advocacy groups. Of course, the U.S. Supreme Court has never said that, but that's now the law here in Wisconsin. In that John Doe 2 case, by the way, the special prosecutor, Francis Schmitz, requested that 2 justices recuse themselves from the case because they had a conflict of interest. The 2 justices were David Prosser and a guy named Michael Gableman, whom Justice Butler is very familiar with. And I'm sure you're familiar with him too, because he's been in the news over the last year and a half. The special prosecutor noted that both Prosser and Gableman had benefited from extraordinarily large donations from 2 of the groups that the special prosecutor was investigating, Wisconsin Manufacturers and Commerce and the Club for Growth. Combined, they had spent, according to our calculations at the Wisconsin Democracy Campaign, $2,260,000 to help Gableman get elected and $1.6 million to help Prosser get elected. Not only did these two justices not recuse themselves, they voted to fire the special prosecutor, which happened. Also in 2015, the Republicans in the Wisconsin legislature rewrote our campaign finance laws to double the amount of money that super rich individuals could give to their favorite Supreme Court candidate, from $10,000 to $20,000. And they tore down the de facto limit on donations to the political parties, which was $10,000, and they didn't replace the ceiling at all. Now the sky's the limit on what an individual can give to the political parties. And that makes a joke of having a limit on direct donations to candidates. Because look, if you're for Judge Janet, you could give $20,000 to her campaign and then $2 million to the Democratic Party of Wisconsin, which could then turn around and give $2 million to Judge Janet's campaign. Same thing if you're for Kelly. You could give his campaign 20 grand and then the Republican Party of Wisconsin $2 million or more, which could then give that amount to the Kelly campaign. This turns the political parties into little more than glorified laundromats. So that's the context. But in looking over the past 20 years of Wisconsin Supreme Court races, what struck me is that the jump in spending actually happened before some of these decisions that have just opened the floodgates even more. Here's a personal anecdote. I used to live a block from West High School here in Madison. And I would frequently shop at the Regent Co-op, which we used to call Joe's after the former owner. Well, one day I was at Joe's and Linda Clifford, my neighbor, was in line ahead of me. A highly respected attorney. She was running against Annette Ziegler for a spot on the court in 2007. And so I asked her, how's the race going? And she told me, I'm getting killed by all the outside money. She lost that race, and she was right. The outside money was brutal. And this one, outside groups spent $3.1 million, more than 100 times what they'd spent in 2003. Wisconsin Manufacturers and Commerce itself shelled out $2.2 million for Ziegler, and the Right Wing Club for Growth spent $400,000 on behalf of Ziegler as well. The Liberal Greater Wisconsin Committee spent $400,000 for Clifford, but it all was, too little, too late. And then in 2008, outside groups spent $4.8 million when Michael Gableman challenged Louis Butler. The Gableman campaign ran hideous ads against Butler and was aided by $1.8 million in expenditures by Wisconsin Manufacturers and Commerce and $500,000 from Club for Growth. The Greater Wisconsin Committee, the liberal outside group, poured in $1.5 million for Justice Butler. But again, it was too little, too late. The money that started to explode in Wisconsin in the middle of the first decade of the 21st century was part of a nationwide trend. Big business groups mounted a concerted effort to grab control of the state courts. The Brennan Institute and a couple other groups issued a report that year that said state Supreme Court elections attracted record sums from business interests. The same year, former U.S. Supreme Court Justice Sandra Day O'Connor put it this way: in too many states, judicial elections are becoming political prize fights where partisans and special interests seek to install judges who will answer to them instead of the law and the Constitution. For a relatively small investment, big business coalitions and right-wing ideological groups understood that they could gain control of state Supreme Courts and get what they wanted from them. And so they threw themselves into this task, succeeding here in Wisconsin and elsewhere. Not to be outdone, liberal groups countered this threat by raising tons of money of their own, and off to the races we've gone. And that's where we are today. The leading outside groups in the race so far right now are A Better Wisconsin Together, which is a democratically favored group, which has raised $3,784,000, and Fair Courts America, which is fully funded by Richard Uihlein, the billionaire co-owner of the Uihlein Corporation, who lives in Lake Forest, Illinois, and they have spent $3,350,000. So it's pretty close. It looks like it's coming down to a race to see if Ben Wickler, of the Democratic Party of Wisconsin can speed dial billionaires faster than Richard Elon can transfer money into his Fair Courts America PAC. So that's kind of where we are and how we got here. And I just want to ask Justice Butler if I said anything that rubbed him the wrong way or the right way for that matter, if he wants to comment on those brief introductory remarks I've made.
Thank you, Matt. No, I think you've set the table fairly well. And I know one of the reasons we're here is to talk about the issues of judicial recusal or disqualification, which is another term that's used here in Wisconsin. We have both the statute and the Supreme Court rule that govern the issues of recusal and disqualification. So what I'd like to do to kind of stress the importance of what the issue is and why we're talking about this at all is I think it would be helpful to discuss a case called Caperton versus Massey and talk about what that case stood for and why it was important. Now, I want to be very careful because I know I'm convinced that we're not going to have a ton of lawyers on this call. At least I don't think so. So I don't want to get too deep into the weeds, but I think it's important to understand why this case was considered so pivotal at the time it was decided. So I want to go back to 2009. This was shortly after my election. There was a case that weaved itself through the West Virginia court system. This Caperton coal company versus this Massey oil company. The case went to trial. Basically, Caperton alleged that it had been landlocked by Massey Oil. It couldn't get its exports out. It had been shut off from doing what it was supposed to do business-wise by the Massey company going in and buying all the land around where they were located. So they filed a lawsuit and it went to the local court, and Caperton won its lawsuit. It obtained a $50 million judgment. The owner of Massey Oil, Doug Blankenship, understood the dynamics of the West Virginia Supreme Court. There was Chief Justice McGraw in the court, who he knew he had never gotten that vote. So he decided, I'm not going to win by persuading the court, but I might be able to win by changing the court. So he donated the maximum amount he could to the candidate, $1,000. He then provided an independent expenditure, and I hope I get the numbers right because I'm doing it from memory, and if I state them wrong, I apologize. But I believe he spent $500,000 for an independent expenditure where he ran his own ads in favor of Brent Benjamin. He then gave $2.1 million, I believe is the correct amount, to a group known as For the Sake of Children, and urged them to unelect Chief Justice McGraw. That case, so we're talking about a $3.1 million investment in the election. Chief Justice McGraw is defeated. Chief Justice Benjamin becomes the deciding vote in a 3-2 decision. And interestingly enough, two of the justices recused themselves in that case, one of whom had been photographed on a ship, I believe it's according to the ABA Journal, drinking with Doug Blankenship. So two of the justices recused. The vote total at the West Virginia Supreme Court was 3-2, and the $50 million judgment was overturned. That was the case that found itself in the United States Supreme Court. And the issue was whether or not due process had been violated by Justice Benjamin sitting on the case after receiving such a large contribution from one of the litigants in the case. That was the issue that went up there. And it's interesting to kind of examine the dynamics of what was going on in 2009. My election had just completed. Then Chief Justice Abrahamson was supposed to be up in 2009. There was a lot of talk about the money that might be invested in Wisconsin in 2009 and in other states. When the oral argument occurred, and I actually read the oral argument years ago, I haven't read it recently, but I read it years ago, Justice Kennedy started asking questions that indicated that he might not be on board with the proposition that this was perfectly all right. There might, in fact, be something wrong. And so he starts asking questions to kind of tip his hand that this bothered him. After the oral argument, at least for the remainder of 2009, the dark money nationwide from both sides kind of dried up. Nobody spent any money out from outside groups, or at least a large sum, in any of the elections until after Caperton was decided. But when Caperton was decided, the court did hold that when that largest sum of money, $3.1 million, is spent in a case that was litigated before the court, it provided the appearance of impropriety, and it made it look as though justice could be bought. And so the court basically overturned the decision and remanded it back to the West Virginia Supreme Court for a decision, with Justice Benjamin being taken off the case. So that was the thrust of the due process issue that we now knew existed. Now, a year later in 2010, Citizens United comes down. When Citizens United comes out, it basically held that corporations are basically the same as people, and they have a First Amendment right to spend as much as they want for any candidate that they want. And there's nothing inherently wrong with that. Now, when you read the two decisions together, what it suggests is that, yes, groups can spend to support a candidate of their choice, but they don't necessarily get to keep the judge on the case if they spend in that fashion. There's still a due process consideration, and you have to look at those issues. And I tell you that because after Caperton and Citizens United came out, in 2010, 4 petitions were filed with the Wisconsin Supreme Court. Now, this is after I'm already off the court. 4 petitions were filed, one by former Justice Bill Bablich, rest his soul, a good man, good justice. One by the League of Women Voters, both trying to fashion a recusal rule that would kind of codify the Caperton decision and the due process issues that were raised in Caperton. 2 other petitions were filed the same year by the Wisconsin Manufacturers and Commerce, and by way of disclosure, they opposed my election in 2008, and by the Wisconsin Realtors Association, and by way of disclosure, they supported my election in 2008. They took the opposite position that if they're spending by large spending by these groups, these outside money groups, was okay, and both groups drafted a rule. So there were 4 petitions before the court. The courts considered the 4 of them. They adopted the 2 petitions by Wisconsin Manufacturers and Commerce and by the Wisconsin Realtors Association verbatim, which in fact created a slight problem because after they were adopted, the court found out that they were kind of internally inconsistent, so they had to repair the damage. But those 2 rules were then drafted. And it's important to understand the context of what the rules said when you think about the issue of due process that Caperton talked about, because what the court, the rule that the court passed, it's 60.04, Supreme Court Rule 60.04 sub 7. A judge shall not be required to recuse himself or herself in a proceeding based solely on any endorsement of the judge's campaign committee or the judge's campaign committee's receipt of a lawful campaign contribution, including a campaign contribution from an individual or entity involved in the proceeding. Now, this was new. Usually, if people were litigants in a proceeding, that was kind of automatic grounds for recusal, not necessarily the lawyers, but the litigants themselves, the parties. If the parties were involved, that would be grounds for recusal. Then the court also added sub 8, effective independent communications. A judge shall not be required to recuse himself or herself in a proceeding where such recusal would be based solely on the sponsorship of an independent expenditures or issue advocacy communication collectively, and independent communication by an individual or entity involved in the proceeding, or donation to an organization that sponsors an independent communication by an individual or entity involved in the proceeding. Essentially, the court, by adopting these 2 rules, read out the due process side of Caperton in favor of the large money side of Citizens United, because if Citizens United says it's a valid legal contribution, it's okay. Well, we know it's okay, you can give it. The question is, do you keep the judge? But the recusal rule in Wisconsin says that's not a basis for recusal. This created a great deal of concern among a number of retired judges and justices. I was one of them. A petition was filed in 2015 with the Wisconsin Supreme Court after about 2 years of deliberation. The retired judges would meet, establish a number of committees, wanted to draft language that would incorporate all of the issues that could be involved in this recusal / disqualification type issue, and presented a proposed rule change. Like I said, it was originally 54, the 56 eventually signed the petition. And that proposal was submitted to the court, and the court denied it without a hearing. So Wisconsin has been, according to a number of different publications, it's rated as the 4th worst recusal rule in the country. And we're in a situation where you have to be concerned about the amount of money that's being donated on behalf of candidates, either direct money or independent money. And the irony about this particular webinar is a couple of days ago, one of the groups that donated that wrote the rule in 2010 that was adopted by the court, Wisconsin Manufacturers and Commerce, according to published reports, so I hope I'm accurate because I read this in the newspaper, has donated $3.2 million on behalf of one of the candidates for spending on ad buys in the last couple of weeks before the election. That was the story that I read just yesterday. So you think about that, the amount of money that's being spent in this ad buy is more than the amount of money that was spent when the United States Supreme Court said that recusal was required in the West Virginia case. That's the issue that we have. And the concern is whether you have either an actual conflict of interest or an appearance of conflict. The concern by the public is whether or not justice is being decided on the basis of facts and law, or whether it's being decided on the basis of who your friends are. That's the concern. And I'm not here to suggest that anybody is doing anything inappropriate under the law with these donations, because we know that the law allows these type of donations to exist. Now, there is a side issue with recusal that can't be ignored. And I think people need to be aware of this as well. And it kind of coexists with the rule of necessity. And I bring this up because in Wisconsin, we do not have a procedure for replacing a Supreme Court justice who steps off of a case. So if a justice were to recuse themselves or disqualify themselves from sitting on a case at the Supreme Court level, there's no one to sit in their stead. And what that means is that you might not have a case heard. There was an individual in 2009, excuse me, I think it was 2009, who had filed a petition for review in the Wisconsin Supreme Court. He had ties, political ties. He was the former president of the Milwaukee Police Association, so he had political ties with a number of the justices. 5 of the 7 justices recused themselves from hearing the petition for review. So the petition was dismissed for want of a quorum. There was no court to hear his case. So you do have concerns about when a judge or justice gets off of a case, who gets to hear the case. Now, at the lower court level, we know that you can have another judge step in. At the Court of Appeals, you can have another judge step in. That's not true at the Supreme Court level. So there is this rule of necessity that people need to be aware of, about why sometimes it's necessary to sit, or if you don't, sometimes you don't have a court and you don't get your case heard, as that individual did not have take place. But when you look at this rule, and particularly the due process considerations, you have to, at least I'm concerned about the amount of money that is spent, particularly the outside money, because one of the things that I learned as a candidate in my own race is if you don't control the spending, and we had an anti-coordination law in Wisconsin, so I wasn't allowed to coordinate with other groups. If you cannot coordinate with organizations that are spending on your behalf, you are not controlling the message. So who I am as a candidate is not necessarily what's being heard by the public. Who people think I am is being heard by the public. And the more money that's spent, the more people tend to believe that that is the reality. And trust me, it's difficult to try to tell somebody who you are in 30 seconds. So this is an important issue for Wisconsin. It's my hope that the Wisconsin Supreme Court will revisit the recusal disqualification issues again in the near future. I think it's an important issue, particularly given the impact of Citizens United and McCutcheon, even when read with the issue of due process. So that's kind of my take on it at this point. I hope I've covered everything I intended to cover, and certainly will attempt to answer any questions that I can. So,
Justice Butler, if I can just ask you a couple myself before we get to the crowd. I mean, the rule on recusal now, the existing rule is essentially no rule at all. I mean, essentially it says that it's up to the judge or the justice whenever he or she is faced with a question as to whether there's a conflict of interest. It's just up to that person to decide, right? Am I right about that?
Well, at the Supreme Court level, that is right. There is appellate review at the lower court levels, at the trial court and the Court of Appeals. But at the Supreme Court level, there is no higher court to tell a Supreme Court justice whether they should recuse or not recuse. And so it's left up to the individual. The part that, and I want to say this on behalf of all judges, many judges who are there, regardless of their political or philosophical affiliation, are up there because they think they have the right interpretation of the law. Whether you agree with them or not, that's a separate issue, but many judges are there to try to do what they think is right. If you have a candidate who is not controlled by ethical considerations, these rules can be misused and abused. And we've seen that in other elections and other jurisdictions, not necessarily for courts. There are situations right now being covered out of Congress that have raised some of these questions about whether or not people are following rules of ethics or not. So for candidates who are living by a code of ethics, I think they'll try to do what they think is right, but not every person who runs for office is necessarily going to follow a code of ethics the way I might think a code of ethics should be followed.
Aaron, we can take questions.
Great. I was just going to ask because we do have several on recusal, and so I would like to get those questions to Justice Butler if we could. One I thought was a really good question. Should a judge also recuse themselves from cases involving entities that worked against the judge in their campaign?
And I think that's a very good question, which is also subject to abuse from both sides. I mean, obviously, if somebody wanted you off their case, that would be a way of going in and approaching it. And I think this goes to the question that Matt just asked. The judge has to determine subjectively first whether or not they're going to be biased. And if they're subjectively biased, that's a no-brainer. Yes, you have to get off the case. The question is, are you objectively biased because somebody spends a ton of money to not elect you? And I don't know that the appearance of impropriety is as strong as when somebody donates on your behalf. But I can see why parties who spent against you might be concerned that you're deciding their case, but that doesn't necessarily mean that you are going to rule against them because they oppose you. I mean, I can think of numerous situations where that can come up. So I think it's a little bit different, but it is, to say it's not a concern, I think is to ignore how some people might react. I mean, we just had someone who's a candidate now talk about retribution. So you have to be concerned, are people thinking like that? I don't think many judges think that way, but that doesn't mean that somebody could.
Okay, we have a couple more here, and I think all of these are quite good. One is, if recusal were to become the rule, do you worry at all that you could end up in a situation where no judge could be available to hear the case? Like with someone who just donates to so many candidates that there's no one left, I guess, to hear the case.
Well, first of all, recusal is the rule. It's just how it's being interpreted. There is a recusal rule, 60.04 sub 7 and sub 8, and then the disqualification statutes 757.19. So those are the rules that govern. But there is a concern in Wisconsin because unlike many states who have at least at the Supreme Court level, a mechanism for replacing judges, Supreme Court justices who step off of a case, we do not. And so in the case that I had mentioned before, that the individuals whose case could not be heard, yes, that is a concern. Now, one way to address that, I don't know that it will be addressed. I don't know that anybody's even thinking about addressing it, but one way to address it would be to draft a constitutional amendment that would allow for temporary replacement of Supreme Court justices who recuse themselves or were disqualified off of cases, similar to what they have in other jurisdictions. We just don't have that here. So if you don't have it here, yes, it is a concern. If you have more, you need to have at least 4 to create a quorum on the Wisconsin Supreme Court. You need 4 people there. So if you don't have 4, you don't have a quorum.
The 54 judges or 56 judges and former justices who petitioned the court for a new recusal rule, they did provide for the possibility of amending the Wisconsin Constitution so that appellate court judges could come up and sit in on a case and other mechanisms. So there's a lot of thought put into the very question that you've been discussing, as I'm sure you know.
Right.
Okay. We actually have a few more. I find this really interesting. People have got great questions coming in. I love this one. Are there retired judges who aren't in favor of recusal who have organized in any way to express their views that you know of?
Is that for me?
Sure. Either one of you, if you know of it.
Yeah. No. There were judges on both sides of the issues when the petition went up in 2015. There are other judges or justices that thought the current recusal rule is just fine. So I don't want to say that the 56 spoke for every retired judge or sitting judge in the state. That would be a misnomer. But I can tell you that there was a significant support from at least the retired judges that submitted that petition. And I think from a number of media sources as well. I think there were a number of editorials in favor of coming up with the recusal rule that was proposed. And I want to be very careful because for people who don't understand, we have recusal rules in Wisconsin. The question is, do they govern large spending by outside donors? And is that a basis for recusal? And according to the rule, it in and of itself is not.
Okay, and that actually brings up another question that came in, and this is again for both of you. You've both mentioned outside donors, outside money. Is there a good definition of what that means when someone's outside money? What does that mean?
Well, I mean, outside money has a couple meanings. So the first meaning is it's not spending that's done by the candidates' committees themselves. It's not the candidate's campaign that's putting on the ad. The ad's run by an outside group. They usually have, they're supposed to have a disclaimer at the end that identifies at least the name of the group that's spending the money. Outside money also can mean money from outside of Wisconsin. And I do think the tons of money that are coming from outside of Wisconsin, that kind of money is a problem too when you get down to self-governance. And, you know, why should a guy who lives in Lake Forest, Illinois, or someone who lives in California or New York or Nebraska. And this happens on both sides. I mean, for both parties and both ideologies, they're getting huge amounts of money from right-wing billionaires and left-wing billionaires across the country. But of course, our politics shouldn't be a tug of war between a handful of billionaires on the left and a handful of billionaires on the right. In a real democracy, we all have an equal tug on the rope, and we just don't, because of the huge amount of money that's coming from outside of the candidates themselves and outside of the state itself. That's what I mean by outside money, those two things.
Justice Butler, did you have anything to add on that, or?
No, I think Matt covered it.
Okay.
You're talking about outside the state, you're talking about outside organizations. In some states, there are disclosure rules where the outside organizations have to disclose where the money is coming from. In other states, there are not. And so disclosure becomes a big issue. And it's interesting because when Caperton was argued, I know one of the big issues then was whether or not there was disclosure, and at least the representations, as I recall, and I'm doing this from memory, the representations made to the court was that disclosure was a big part of the reason for the rules that they were requesting. And so I think there was an assumption, at least in 2009, that disclosure was going to be part and parcel of all of this. I don't think that is necessarily the case now.
And if I can just piggyback on that, even in the horrible decision that is Citizens United, the justices in the lead opinion of Citizens United said the cure for this outside money is more disclosure. And of course, we don't have more disclosure here in Wisconsin. There's no requirement for disclosure for the so-called issue advocacy groups under the Wisconsin Right to Life decision. And there have been bills proposed in session after session that would require disclosure, more disclosure, and those bills just don't pass. And so we have a lack of disclosure on the issue advocacy front. And, let me just be a little clearer on what an issue advocacy group is. This is a group that doesn't use the magic words of vote for or vote against a candidate, but you've seen these ads all the time. Call Governor Evers, when he was running for, call Governor Evers at 608 whatever and tell him to stop being such a horrible governor, or whatever slanderous thing they're saying or mean thing they're saying about a candidate. The purpose of that ad is to tell you not to vote for Governor Evers or whichever candidate you're saying, call that person up and tell them to stop being so horrible. I mean, it has the same effect as an ad that says vote for or don't vote for so-and-so. But because they don't use these magic words that the U.S. Supreme Court has talked about, they don't have to disclose who their donors are. And that's kind of a joke in and of itself. A bad one.
I definitely have seen those ads. So we do have a couple of other recusal questions. I want to get to all of those. Right now, let's wrap up a little bit of this and go back to, Matt, some of your topics. But I think these two questions kind of go together. One is, could much of the recusal issue be cured by eliminating judicial elections and having appointments instead? And then kind of a similar question to that would be, how does the Wisconsin recusal rule compare with rules in other states? Again, I think there are states in which judges are not elected. So love to hear your thoughts on that.
All right. I guess I'll go first. I don't know that the recusal rules are cured by appointments necessarily versus elections, because you still have the concern about who the appointing body is, whether or not it's coming from one side or another, who has bankrolled or financed the campaigns of the people making the appointments. So there's still concerns about who gets to the court. I mean, a perfect example is if you look at the configuration of the federal court system, which are judicial appointments, they change over time depending upon who the appointing president was and the decisions, how they look on the basis of the resulting philosophies of the people who were appointed. And so I don't know that the recusal issue goes away totally. It's still there. You still have concerns. You don't have the large donation concerns to the candidate. That goes away. But I would have perhaps a different suggestion in terms of and I'm not, and I know I'm in the minority on this. I've said this to other people before, and all of my good friends, my good friends throughout the state, they yell and scream and holler at me when I say this. But I think one thing that we have to consider in Wisconsin is perhaps, as much as I love a nonpartisan judiciary, and I tried to run my candidacy in a nonpartisan way, the reality is that these have become largely partisan elections. And the danger with having a nonpartisan election that is partisan in fact is that you can have a ton of money coming into a small turnout election in April. And I think Wisconsin historically is one of the smallest turnout states in April elections, when we're one of the largest turnout states in November elections in the partisan election cycle. So if you had these elections occurring when people are actually voting, when they are voting, and you also had, if you got rid of the fiction, nonpartisan versus partisan, and said, I'm going to run as a Democrat or I'm going to run as a Republican, then one of the things you can hopefully avoid are judicial candidates taking positions on substantive issues, which is arguably questionable. And you can have, I'm just going to run as a Democrat or Republican, and then everybody knows who's backing you, who's supporting your election candidacy, and you get the turnout, which minimizes the outside money, because now if you have that election going at the same time as president, governor, United States senator, Congress, that money's got to be split up in a whole bunch of different ways. And so you can't just all dump it in on an off-season Supreme Court election. So I think it would actually minimize the outside money that can impact. Not, it wouldn't get rid of it, but it might minimize it to a degree. So one of the things that I've talked about is, should we consider changing this state to a partisan election in November, and hopefully so that judicial candidates can avoid taking positions substantively on issues during campaigns, which is something that I think could be problematic.
Well, I do think I don't have a problem with having the elections in November when there are bigger elections going on. I do want a big turnout election. I actually think the turnout this time is going to be pretty high compared to previous ones. Previous ones, we've, the numbers we look at are 20%, sometimes 18%, occasionally up closer to 30%, but usually pretty low. And in presidential races, the turnout's huge here. And we need to have higher turnout. I'm against appointing judges, though several of my friends, Scott Milford at the State Journal is a big advocate of that. Ruth Kahn of the Wisconsin Examiner, who I used to work with at Progressive Magazine, she's an advocate of that. But I do think it's important to give citizens this right and keep this right with the citizens. It's one of the few times we have as much power as the richest person in the state is when we go into that voting booth. So I don't want to take that away. And I do agree with Justice Butler that, there's still a problem with appointees and money, because who's funding the appointer? So that, I think that's a solid point he made.
So another question we had that kind of is a follow-up to this is, so it sounds like appointments not necessarily going to take care of the problem. Is there something that can be done to limit the influence or to make a judiciary that's less dependent on political parties, or that's more independent from political parties? Because it sounds like Justice Butler, it sounds like you were almost advocating, hey, let's have the elections all at the same time, make it a partisan election, so at least everyone knows it's out there. But is there a way to make judges more independent of the political parties?
Well, there is, but the United States Supreme Court says it's unconstitutional. If you can't have campaign finance reform and limit the amount of money that's being spent on these elections, and if the deep pockets can spend as much as they want, they might not be able to keep their judge if we get an appropriate recusal rule, but at least it follows Caperton. But if you can spend as much money as you want to put in your candidate at various positions in the judiciary, then this problem is going to be there. So yes, campaign finance reform. I was a strong advocate for that for years. I think it's the way to go, but you would have to change the mind of a majority of the United States Supreme Court justices in order to have that fix in place. And so then if you can't have that, then the question is, how can you have fair elections for judiciary if you're going to have elections, or do you just go the appointment route, and how do you create a fair appointment system? And I don't know that there's an easy answer to either of those questions, which is why one of the things that I've been wrestling with for the last few years is, should we just send it over, let the people vote when everybody shows up in November? The one concern I think that, of course, I always have, and I've joked about this over time, is that, and this is the reality that I think we all face, no one cares about a judge until you're standing in front of one. And then if we're honest about it, you don't want a judge who's fair and impartial. You want a judge who agrees with you. And if you can't have that, then you want a judge that's fair and impartial. And I think the only answer is to have fair and impartial justice. And you have to have somebody who's not going to take sides in a case. But you have to convince the voters and the public and the elected officials and the donors that is what will make for the best system. Because until everybody sees that, people want somebody who's going to agree with them.
Yeah, I mean, there's no easy solution here. Look, the long-term solution is to amend the U.S. Constitution and say corporations aren't persons and money isn't speech, and you can have reasonable regulations of advertising during an election. That's a long way off, though there are 169 communities in Wisconsin that have urged the legislature, urged Congress to do that. And a group called Wisconsin United to Amend has done a lot of the great work on that. I do think it is possible to get a different majority on the U.S. Supreme Court. And I think Justice John Paul Stevens' dissent in the Citizens United case would serve as a kind of a landmark roadmap for how you get to a better jurisprudence on campaign finance, but that's a ways off too. We had here in Wisconsin for a few years, just like 2 years, starting in 2009, we had public financing for our Wisconsin Supreme Court races. This was called the Impartial Justice Act, which we were behind, which the League was behind, which Common Cause was behind. It wasn't a cure-all because, of course, it couldn't deal with the outside money, the funding from these independent expenditure groups that tell you explicitly who to vote for, and then the funding from the dark money groups who say, call this candidate and tell the person to stop being such a scoundrel. And so when you can't fix the outside money, it doesn't do all that much good, though we were strongly in favor of it to have public financing for Supreme Court. One thing the legislature could do is put a ceiling, again, a pretty low ceiling, on what direct contributions can be made to the justices, and also especially, and maybe there are Republicans who are ruining the day that they tore down the ceiling on direct donations to political parties, because Ben Wickler's better at raising that than his counterpart in the Republican Party of Wisconsin. But why there's no ceiling whatsoever on what any individual, not only in Wisconsin, but across the country, can give to the Republican Party of Wisconsin, the Democratic Party of Wisconsin, is just beyond me. There's nothing in any of those court decisions that I discussed or that the justice discussed that prohibits you from putting a limit on donations to political parties, state by state, or here in Wisconsin specifically. So that's a real problem. And we do have donors right now in this race, and we did in the governor's race, who are giving the maximum amount, $20,000 to the candidate, and then turning around and giving 100 times or 200 times that amount to the parties, and the parties then turn around and give it to the candidate. That's insane. I mean, it's a foolish way to have any kind of campaign finance system.
All right, so we have one question here that I think we're going to need to put on our Nina Totenberg hats for a moment. It might be fun. If we had the recusal rules that the 56 retired judges wanted, and it were challenged at the Supreme Court of the United States, what do you think would happen in the current climate? And Justice Butler, do you want to take that one? I think you're on mute.
I hit the wrong button. All right.
There you go.
I'm going to have to do this from memory because I haven't gone, even though I worked on I was one of the group that helped to draft the petition. I haven't read it in some time now. But my recollection is that we were very careful to take into consideration the court's positions, not just with Caperton, but also with Citizens United and McCutcheon. And that we drafted the rule in a way that would be constitutionally acceptable to the current court. That was the intent when we drafted. We understood, and I understand there are limitations. There are clearly First Amendment issues that involve speech and whether or not a person has a right to support the candidate or candidates of their choosing. So those issues are there. You can't ignore those issues. The question is, do you also have a right to a fair and impartial judiciary? And do you have a right to have a court that can make decisions on the basis of fact and law, as opposed to on the basis of friends? And so when you look at the way we drafted the recusal rules in Wisconsin, it tried to take into account, at least the proposed rule that we drafted, we tried to take into account the fact that those First Amendment rights existed. But that doesn't necessarily, and this goes to the point I was making at the beginning, that doesn't necessarily mean that if you are successful in electing your candidate, you get to keep that judge or justice as a judge on your case. And so that's where I think we tried to blend the cases together to make sure that that met with constitutional acceptance. So I think the rule that was proposed by the retired judges would meet constitutional muster. Like I say, I'm doing that from memory because I haven't looked at it in a while. So,
well, I'm a little less optimistic than the justice, just because the Roberts Court isn't the Roberts Court anymore. I mean, the Chief Justice is in control of his court. The court is much further to the right than it had been when Caperton was decided, so I just think the right-wing ideologues are running the game right now, even more so than they did when Roberts was there, when Roberts had full control of the so-called conservative wing of the court. And I also think the interpretations of this court on campaign finance issues over time have prioritized First Amendment speech rights over 14th Amendment due process rights. And on some of those campaign finance issues, like Clarence Thomas doesn't think there should be any limit, or he's hostile to any limit on any campaign spending under a really expansive view of the First Amendment. And so I just don't have faith in this new right-wing majority that's on the court, as we saw in the overturning of Roe, for instance.
Okay, a couple of questions then for you, Matt, if you don't mind. One is, how much money from outside Wisconsin has been contributed to the Supreme Court candidates since the primary? So it hasn't been too long, but we've had a little bit of time now.
Yeah, and I don't have, I was just looking this up. We don't have the data on that yet. I did read something in one of the newspaper articles today that said there was a lot of money from outside going to Protasewicz's campaign directly. Now, of course, Richard Eline, of that $3 million or so amount from this misnamed Fair Courts America PAC, he's put up every penny of that himself, and he lives in Lake Forest, Illinois. And I know that Ben Wickler's getting a lot of money from big donors, and I imagine A Better Wisconsin Together, which is also the liberal outside group, is getting a lot of money from some big donors. And Protasewicz's campaign too was getting money from a woman in Seattle who had maxed out to Protasewicz, which means giving that campaign $20,000, and then was giving 10 times that to A Better Wisconsin Together. And let me just briefly say, the expression max out is antique now. It's totally outdated. There's no way that any rich person can max out anymore. There used to be this convenient expression that super rich people who like to play in the political sandbox would use when some candidate would call them up and they'd say, I'd really love to help you out, but I've maxed out. I gave my limit, which prior to 2010 was $10,000. If you gave $10,000 to Jim Doyle, you couldn't give a dime to the Democratic Party of Wisconsin or anyone who was running for state assembly or state senate. So, people would say kind of sometimes dishonestly, they'd love to help you out, but they've maxed out. Well, there's no way you can max out now, because you can always give to an outside group because those donations are unlimited. Or you could give to a dark money group. Those donations are unlimited and never disclosed. So that expression is gone out of the vocabulary.
So are there any, and this comes from an audience question, are there any states that are doing this right? Are there any states that have been able to deal with outside money or just money in general influencing judges through state law that you're aware of, either of you?
Well, Montana, Arizona, Maine have all had much more forward-looking campaign finance reform legislation on the books than we've had here in Wisconsin, at least since 2015. And let me just say, in the rewrite of that campaign finance law, there used to be in the law that was on the books prior to 2015, a preamble to the law on campaign finance that talked about the reason for this, that we believe that huge amounts of money can create doubts in the public's mind about whether there's corruption or undue influence, and that everyone's voice should be heard in our democracy. Well, when the Republicans rewrote that law, they took out that highfalutin language, that high rhetoric. And there were amendments proposed by Democratic senators. I was in the Senate gallery at the time when it was being debated, and those amendments were just taken out. So even the purpose, the high-minded purpose of campaign finance legislation has gone by the wayside under the current law here in Wisconsin.
Okay. Let's see. There was another question here I wanted to get to. Oh, here we go. After the, well, this says after the no recusal rule was passed, which I think means after the petition was rejected from Justice Bablich and the others, has there been a recusal on the Wisconsin Supreme Court? And if so, if you're aware of, if so, do you know the circumstances, either of you?
I know there has been a justice who has recused himself or herself in the last couple of years, but I don't remember the case. The justice might remember it, but I don't.
I don't remember any specific case, although I'm also aware that there have been recusals. I can just tell you that just in the petition for reviews that were decided today, that Justice Patience Rogensack recused herself off of a couple of Milwaukee County cases. I'm guessing without knowledge that might have to do with the fact that her daughter is a sitting Milwaukee County judge, and it involved one of those cases. I don't know that to be the case, and don't presume to know the reasons for recusal in a situation like that. But yes, there have been recusals. I mean, I gave one example earlier of the 5 justices that recused from that individual's case and couldn't sit as a court. So there are recusals. There have also been a number of cases where there have been allegations that the justice or justices should have recused and declined, and that has raised the ire of some people who thought that their decisions were inappropriate. I think if anybody wants to look at some of those, you might want to look at some of the research done by the Brennan Center out of New York, who has looked at, I think, that issue.
And the John Doe 2 case is a prime example of that. So There's also another thing I just wanted to throw out. This is kind of adjacent to recusal. This is about just sharing information. The legislator, Gary Hebel of Sun Prairie, for years and years, he's retired, just retired, but for years and years, he would propose a piece of legislation that would require judges at least to disclose when their campaigns are getting funding. Because right now it's legal in Wisconsin. If I'm a lawyer and I'm in court and I give the maximum to the judge at the lower level, which may be $2,000, neither I nor the judge is required to tell the lawyer on the other side that I just gave that judge the maximum amount for his or her reelection campaign. And to me, that is just another real red flag that there is at least the appearance of a conflict of interest here, and an appearance of a justice being bought.
And this is one issue where I think we're going to disagree on that. One and the reason being that if you have this influx of outside money that is coming in from, as you indicated, either billionaires or groups, entities who have a concern about what the courts are doing, and they're trying to elect their own candidates, the only people who know who the judges are who might have a vested interest or stake in trying to put in a good judge or justice are the attorneys that appear in court. And when you have limits, if they are donating to those limits, and the limits have already been declared legal, then you would want the candidate to be able to combat the outside money. You'd want to have some candidate control. And the candidate, and if you don't have the kind of donations that only lawyers are going to care about, if you don't have those donations, then the only people who can run for judicial office are the wealthy. And so for a candidate like me who was not wealthy, you want to have the support of your colleagues in the legal profession. Now, whether disclosure should be part of it, and I don't have a problem with disclosure. I never have. In fact, when I ran my race, I tried to put in place a double-blind system so that I would not know who was giving me money. And so I had the campaign committee. If someone who had a practitioner, and if an attorney had a matter that was pending before the court, the campaign committee would contact my staff. If they thought there was an issue that rose to the level of disclosure, they would contact me, and then I would make the disclosure. It was not perfect, but at least that's a way of doing it. But if you take the lawyers out of the system of donation, then the only people left are the wealthy. And
I was just talking about disclosure.
That's bad.
Yeah, but I think disclosure, I think we agree on disclosure. And that's,
we agree on disclosure. Yeah. Right.
Okay. I just had a question come in that I like. I don't know if either of you know the answer, but I will pose it anyway. Have either of our two current candidates for the Wisconsin Supreme Court stated positions on recusal?
Well, yes. I mean, Judge Protasewicz has said that she would recuse herself on any case brought by the Democratic Party of Wisconsin, because the Democratic Party of Wisconsin has given her campaign $2.5 million. Justice Kelly has not made the same commitment, even though he's been on the payroll of the Republican Party of Wisconsin until recently, in any event. And so there's a question. I do think Judge Protasewicz is in murky water on the abortion issue if Planned Parenthood brings a case because they are spending money on her behalf. And so what is the difference there? Is the difference in the amount, or is the difference in that she's saying she has strongly held views that are public on this issue? So it's different than a case from the Democratic Party of Wisconsin. But I think that's a tricky thing to distinguish.
Yeah, I think along those lines, and I have not heard everything either of the candidates. I haven't heard everything that either of the candidates has said, so I don't want to speak for or against anything that they've said. But I think the one thing that I think the candidates have to draw a distinction in, it's one thing to state a personal opinion about an issue. We all have them. think the public would like to know what our personal views are when they're getting ready to vote for somebody. But you cannot translate that, at least in my view, can't translate that into this is how I'm going to decide a case, or this is going to be my position on the law, or this is my view on what the law ought to be, because then you're stating, you're ruling before you've heard the facts. And so you want to keep your personal opinion separate from the litigation that comes before you. Does the public have a right to know that you have personal opinions? Yeah, I think that might be fair game.
And I do think the public has a right to know, and the people should vote their values, and whoever corresponds to their values. That's one reason why I'm in favor of electing judges and justices. People should have that right. That's what democracy is about.
All right. I think, Matt, might be a great question for you. Do you think recusal is even a possibility while the current system of gerrymandering that we have is alive and well?
Yeah, I mean, I see the two issues as being separate. I think they're both really important issues. We advocate for banning gerrymandering and having fair maps, and we advocate for having a decent recusal rule. We're in favor of the petition that Justice Butler and the other 55 judges and former justices brought before the court. I attended the hearing at the Supreme Court when they discussed it, and also the administrative meeting they were having, whether they were going to go forward with it or not. And the dissents in that by Justice Abramson and Justice Bradley are very worthwhile for people who are interested in this subject to look up, because that was an interesting exchange that all the justices had. But yeah, I think these are separate issues. We need fair maps in Wisconsin. We need a decent recusal rule in Wisconsin.
Okay, and I think you touched on this, Matt, I think earlier, but just for review, I think this question came in earlier and I missed it. Are there any statutory or judicial solutions to the campaign finance limitation problems that you were outlining? And I think this was from quite a bit before, so apologies if you've already, but maybe if you could just restate that.
Yeah, I just think we need to have lower limits on direct donations, and especially limits on individual donations to political parties. I'm a public finance advocate. I know that's not the be all and end all if these outside groups and issue advocacy groups can throw as much money at a race as possible. And I'm for amending the Constitution of the United States to say corporations aren't persons and money isn't speech. I think those are the ways to go.
Well, speaking of speech, we do have a question or a comment here with a question. I believe that the problem of what is said about a candidate outside of their control is equally as important as the money being spent. Do either of you have a recommendation about, I guess, what is said about candidates outside of their control?
You'd like it to be true.
I mean, part of this question also gets to what Justice Butler was talking about, outside groups taking over the dialogue of a campaign because they have so much more money and they're not coordinating with the campaign, or they're not supposed to be coordinating with the campaign. I'm not as concerned about that as I am concerned about the possibility of actual coordination. And of course, in Wisconsin, the Wisconsin Supreme Court has said that you can coordinate with an issue advocacy group, not with an independent expenditure group. But then the legislature rewrote what the law is about the meaning of coordination in that 2015 rewrite of our campaign finance law to make it almost impossible to prove illegal coordination with an independent expenditure group, a group that says explicitly who to vote for or who not to vote for. For there to be illegal coordination, there essentially has to be an explicit offer from the campaign to coordinate with the outside group, and then an explicit agreement from the independent expenditure group that, yes, we are going to coordinate. And a lot of stuff can be done with a wink and a nod. A lot of times the people running or being intimately involved with the running of the independent expenditure group, used to work with the person who's running for office. And so there's a lot of shared knowledge and shared assumptions and maybe not explicit coordination going on, but there's a lot of coordination going on. They're not uncoordinated, if you will.
And just to touch back to the original premise of the question, I think, and Matt, you covered the coordination side, but there is the concern about how a candidate, either from groups supporting or groups opposing that candidate, loses control over their message because they cannot raise the kind of, their campaign can't, because the candidate can't raise any money in judicial election. The campaign cannot raise the kind of money that they can control that can combat the message. So if messages are put out there that are either misleading or false, and you can chase that message all you want, but to try to do it 30 seconds at a time when millions of dollars are being spent in an election, it's kind of like chasing your shadow. It's very difficult to do. And so unless there's some way of enforcing honesty in elections, I think what we've gotten used to, and I think there was a term that I recall from when I was on the court called puffery, that deals with advertising, that certain amount of puffery is acceptable. But when you're starting to use puffery in a way, or as a means of misleading who the candidate is, either for or against, and so that the candidate that is on screen is not the person who's running for election, well, then who are the voters voting for? They're voting for that screenshot 30-second version that somebody else has invented, as opposed to the person who is running for the office who's going to be sitting there in Wisconsin for a 10-year period of time. And so I think, for me, honesty, truthfulness is an important message that needs to come through. How you enforce that, I don't know, because I'll just leave it there.
And the weird thing is, under existing law, I think Communications Act of 1934 or whatever, TV stations and radio stations are required to run ads by candidates, even if what the candidate is saying is false. And so there's no way around it. Of course, we had an experience in Wisconsin 20 some years ago when Ed Garvey was running for Senate, and he was slandered by Kasten. Kasten won the election, and Garvey sued and settled for $1 or something. And Kasten admitted that he was saying things that were false about Garvey. But that's slim solace. I mean, there's Kasten sitting in the Senate and Ed Garvey sitting on the sidelines because of the hideous ad that Kasten ran. But I think that law's got to be looked at. That 1934 law that says you got to run a false ad from a candidate. I think it was designed to say that they didn't want the radio networks deciding what's true and what's false and give every candidate an equal shot. But that's just a license to lie on TV and on radio. But radio stations and TV stations don't have to take the outside money. They're not required to take, but they have a huge vested interest in taking, because they're getting paid, taking these, hideous ads. Look at, in Mandela Barnes's race, we had some of the most racist ads I've ever seen on TV here. They were funded by Richard Uihlein and Diane Hendricks. Diane Hendricks, the richest woman in Wisconsin, head of ABC Supply. Uihlein, who runs the Uihlein Corporation and lives in Lake Forest. I mean, they were just disgusting. And radio stations and TV stations didn't have to run them. They could have said, this is beyond our standards of decency and we're not going to run them, but they like to cash checks.
All right. I think we'll do one more question from the audience, and then I'll give you both a couple of minutes if you'd like to close with some thoughts about what you want the voters to know before this election. The last question I have here is it even possible for a judge to be elected without large donations from outside groups?
Well, in this day and age in Wisconsin, you either have to, be a telemarketer, a glorified telemarketer if you're running for office, just, calling one rich person after another and trying to get a lot of money in with direct donations for $20,000 or $10,000 or, small donations aren't going to cut it unless you're like Bernie Sanders are going to do it that way. But usually you're just calling millionaires and billionaires, and then you're urging the millionaires and billionaires to give, 100 times that amount to an ideological group that is going to help you out too on the outside. So I don't see how, William Proxmire, for instance, would run for Wisconsin Supreme Court and spend $300 and win.
Yeah, in answer to the question, I think is it possible? I suppose anything's possible. It would be extremely, extremely difficult. Wisconsin is a big state, particularly if you're talking about statewide office. Milwaukee County is a big county if you're talking about countywide office. So is Dane. So doing doors is not going to win an election, even though we know that feet on the ground is the best way to go if you can. But you have to be able to put together some kind of a get out the vote effort, and I don't know how you do that without being able to raise large sums of money. I'm not saying it can't be done, but I think it would be extremely difficult to do.
All right, and then as I said, Matt, would you like to just kind of close for a couple minutes on what you'd really like the people watching tonight and the voters to take with them from this forum about the upcoming election?
Sure. First of all, I want to thank you, Aaron, for inviting me, and the league for holding this panel. And I want to thank Justice Butler for being on here with me. And it's just been a real pleasure just sitting with you and having a little give and take, which I've really enjoyed. And I enjoyed the questions, really smart questions from the folks on the Zoom. I think we need fundamental campaign finance reform. We need ethics reform and tight recusal rules here in Wisconsin. But I do want to encourage everyone on the Zoom to vote and to get your friends out to vote. This is a pivotal Supreme Court race. The question really is whether, what's at stake here. And what is at stake is nothing less than whether our freedoms are going to expand in Wisconsin or whether our freedoms are going to contract in Wisconsin. And the person who is elected will have a tremendous say, more so than almost ever before in any Wisconsin Supreme Court race, about what that answer is. What that answer is when it gets to abortion rights, what that answer is when you get to gerrymandering, what that answer is when you get to voting rights. And then in 2024, whether the Wisconsin Supreme Court is going to throw out tens of thousands of votes that voters cast. I mean, there were 3 arch-conservative justices who were perfectly willing to do that last time around. So that tells you how important this race is. And I hope we have a huge turnout. Huge turnouts are great for democracy, no matter where you are on the ideological spectrum. So I want everybody to vote.
Thank you. Justice Butler, would you like to wrap up?
Thank you, Aaron. Well, first of all, let me thank you as well, and thank Matt. I enjoyed participating on this forum with you, Matt, and I like the give and take as well. And I'd like to thank the League of Women Voters for asking us to do this. The thing that's important that I would like to see as a result of not just this webinar, but also everything that's going on in the state these days, it's important for people to pay attention to who is making decisions about your futures, about your lives. A lot of money is spent on presidential elections. A lot of money is spent on governors races, U.S. Senate races, local representative races, because people think of these individuals as their representatives. But we have 3 co-equal branches of government, and the judiciary is the one who interprets and applies the law to given fact situations. And if you don't know who your judges are, who's making the decisions, and what decisions are actually going before the courts, then you may wake up one day and find out that everything that you thought was the case is different in your future. And whether you are on one side or the other of the Dobbs decision, that's a perfect example of what I'm talking about. So it's really important that for me, that the public, that the people watching this webinar, that people who are paying attention to this election, find out who these candidates are and get out and vote for the candidate of your choice. The one thing, and I've been voting since my first school board race in Appleton, Wisconsin in 1971, and only missed one election primary, school board primary, in one election since then, and that was only because I was in Madison, forgot to vote absentee, and couldn't get back to Milwaukee to vote. And I regret not having voted in that. The right to vote is so important, and people don't understand the roles that the judges have in their lives and their futures. Unless you're like I said, unless you're standing in front of the judge, you really don't know who they are. And so I think it's important. I'd like to see people take from this, go out and educate yourself about who the candidates are, and go out and please vote for the candidate of your choice. And I'd like to see this to be a record primary turnout election. So that's it.
All right. Thank you both so much. This was really enjoyable, really informative. We really appreciate you joining us tonight. Thank you also to everyone who joined us tonight. Great questions, great feedback. We really appreciate your attendance and hope you learned something. Hope you'll pass it on to your friends as well. The League's discussion units will be meeting next week to further discuss these issues that were presented tonight. If you'd be interested in joining one of those, please visit our website at lwvdanecounty.org. I want to thank Jordan Nickel for curating our audience questions tonight, Julia Olson for technical support. This program was planned by the Judicial Integrity Committee of the League of Women Voters, which is led by Janine Edwards. Thank you to Janine, as well as our committee members, Sue Jenick, Lily Crane, Elizabeth Caney, Jordan Nickel, Betty Eberly, and Mary Eberly. Jordan Nickel, Betty Eberly, and Mary Eberly prepared the resource materials for the forum tonight, and you can find those as well on our website, again, lwvdanecounty.org. A couple of announcements before we close. The League of Women Voters is hosting a Lively Issues Luncheon on April 29th at Madison College Truax campus from noon to 2 p.m. And we have a very special guest speaker, Gloria Ladson-Billings. The cost would be $25 per person, and you can register on our website. We also invite you to join our May Forum, which will be about building equitable and sustainable neighborhoods. And more information will be available soon on our website about that forum. You're also invited, we're inviting you to a lot of things. You're invited to join in this month's book discussion, which is about Dark Money, the Hidden History of the Billionaires Behind the Radical Right by Jane Mayer. You can attend a book discussion on Tuesday, March 21st at Penny Library on Cottage Grove Road, or on Saturday, March 25th on Zoom. To sign up, just email books@lwvdanecounty.org by March 17th. Finally, and most importantly, please remember to vote on April 4th. You can find voter information, including your polling location, by visiting myvote.wi.gov. Thanks again for joining us, and good night.